longer hold. Okay. Not it. Test. Good morning, everyone. This is our second microphone check. If you are online, please do us all a favor and make sure that your mic is muted so that we do not get your audio out to the public. We are currently testing our microphones. If you are here in the room, if you approach the podium, please double check to make sure the yellow light is on the microphone and that you are speaking so that you can hear yourself at this level. That way those online and our recording can pick up the audio level as well. And before you leave the podium, once you are done speaking, go ahead and push the button here that says push to turn the light off, as I'm about to do now.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, June 26, 2024, times 9:31 a.m. With us today are Commissioners Bobby Janeka and Katerina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. Registration has now closed, but if you'd like to address the Commission, please visit the registration table or email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. For those addressing the Commission, our General Counsel or I will inform you of your time limit, and we'll let you know when it's your turn to speak. Thanks everybody for being present today. Ms. Smith, please call the first item.
The first item is the consideration of the proposal for decision and proposed order concerning the application by the Port of Corpus Christi Authority of Nueces County for water use permit number 13630. Oral argument time and order will be applicant 10 minutes, protestants collectively 10 minutes, ED 5 minutes, and OPIC 5 minutes. The applicant may reserve time for rebuttal as it bears the burden of proof in this matter. So we'll begin with the applicant, and I believe we have Ms. Bergeron-Purdue.
Good morning.
Good morning. Good morning, Commissioners, Public Interest Counsel, Executive Director, and General Counsel. I am Stephanie Bergeron-Purdue here today on behalf of the applicant, the Port of Corpus Christi. And with me is Sarah Garza, the director for the Environmental Planning Division for the Port of Corpus Christi. The Port of Corpus Christi, we are here to discuss a new appropriation of state water under Texas Water Code Chapter 11. This is a water rights application. It is not a discharge permit application, nor is it a dredge and fill permit application. The Port of Corpus Christi seeks authorization to divert 101,334 acre-feet per year from the Corpus Christi Bay. This is to produce up to 30 million gallons per day of desalinated water for industrial use. At the State Office of Administrative Hearings, the Port met its evidentiary burden, and the ALJs recommended that the application be approved and that the draft permit be issued with changes that the Port generally supports. I will briefly address how the application meets each element of Texas Water Code 11.134 in the same order as the statute. This will allow me to reserve up to 5 minutes of rebuttal. First, unappropriated water is available in the source of supply. The Port's requested appropriation is downstream of the Nueces River and in the Corpus Christi Bay, which is continually replenished by the Gulf of Mexico. Second, the appropriation is for industrial purposes, a recognized beneficial use under state law. The desalination facility will convert lower value seawater into a higher value alternative water source. The application is not speculative. It is development of an alternative water supply to support future needs and is inherently forward-looking. Next, the appropriation will not impair existing water rights or vested riparian rights. Because water in the bay is continuously replaced, the proposed diversion cannot impair existing water rights. Protestants raised concerns about potential impacts to Mr. Serna's littoral rights, including his right to build and maintain a dock, but these are not encompassed within a Chapter 11 permit review. In addition, the application is decidedly not detrimental to the public welfare. Desalination will alleviate the strain on existing water supplies, increase the availability of fresh water for municipal use, and help with drought resilience. The record shows that intake infrastructure has been thoughtfully and carefully designed to not interfere with navigation or recreation. Further, environmental flow standards for Subchapter F have been considered. The Executive Director determined that the diversion point will be located downstream of the relevant measurement points and will not impair the freshwater inflow regime. Importantly, the administrative law judges left to this commission the legal question of whether the Water Code requires additional fish and wildlife habitat assessments beyond the e-flow standards. The legislature's plain language demonstrates that the established standards subsume additional assessments. 11.147E3 specifically states, notwithstanding 147B through E, an e-flow analysis will apply instead of those subsections. In other words, when an adopted e-flow standard applies, the Commission need not conduct additional assessments. and all parties agree this EFLO analysis has been appropriately considered. Notwithstanding, the record goes even further than what is required because the port performed these detailed site-specific assessments of the effect of the permit issuance on fish and wildlife habitats. Considering this extensive record, the Commission can impose discretionary measures to address any impacts, and Special Condition 5B appropriately includes such measures. Shifting from EFLOs, the proposed appropriation addresses a water supply need in a manner that is consistent with Region N and state water plans, with the Region N plan identifying the La Quinta facility project by name. Finally, the port provided evidence that reasonable diligence will be used to avoid waste and achieve water conservation. The port complied with all water conservation plan requirements, including the adoption of reasonable water conservation measures, which will be reviewed and updated at least every 5 years. The port supports the ED's original Special Condition 5B in the draft permit, as well as the additions from the ED's exceptions brief requiring a detailed statement and plan under Water Code 11.144. The port's exceptions propose an intake velocity limit and screen sizes. The port accepts to the ALJ's proposed Special Condition 5B language because it precludes flexibility in implementing new technologies. As a housekeeping matter, the applicant respectfully requests revising the ALJ's proposed conclusion of Law 41 to include 288.7 as a citation. And then in sum, the record demonstrates the port's application has complied with agency rules in Chapter 11 of the Water Code. We ask
That's
that you
5 minutes.
we ask that you adopt the ALJ's recommendation, grant our exceptions, and issue the permit. We are available for additional questions. Thank you.
Thank you. Seeing no questions, thank you.
And now we have Eric Allman and Marissa Perales for the protestants.
Good morning.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, Office of Public Interest Counsel. My name is Eric Allman. I'm here on behalf of Ingleside on the Bay Coastal Watch Association and Sean Cerna. With me today is Marissa Perales. The application before you today is for a purely speculative permit. Port's prior general manager, multiple board members, and memorandum in the record demonstrate that the port has no intent to use the permit being granted. Rather, the port is seeking the permit to put on the shelf and invite somebody else to use. This invitation for use is contrary to the conservation goals of the overarching statutory scheme and sets the precedent that would result in the waste of state resources for unnecessary permits. Furthermore, the port has not provided the properly required drought contingency plan. TCQ Rule 295.9 commences by saying that an application relating to the appropriation or use of state water must include water conservation and drought contingency plans meeting applicable requirements contained in this section. 295.1, the rule plainly states the water conservation and drought contingency plans submitted with an application to appropriate water for industrial use must be submitted in accordance with the guidelines set forth in Chapter 288. This is an appropriation. This is for industrial use. So under the plain language of that rule, it's required to submit a drought contingency plan consistent with Chapter 288. The ALJ's attempt to imply drought contingency is required to the absence of a reference to a drought contingency plan in subparagraph 2 of 295.9. This is directly inconsistent with Commission precedent, who often require drought contingency plans for wholesale water suppliers. Looking to Chapter 288, Section 288.2 sets forth the requirements for drought contingency plan for a wholesale water supplier. There's no dispute the port is applying to be a wholesale water supplier. The plain language of the first sentence of the rule states that a drought contingency plan for a wholesale water supplier must contain the following minimum requirements. There's no language of limitation in this sentence to only a public water supplier. Context may be used to resolve ambiguous language around a statute. There is no ambiguity to this language. That level of specificity limited to a public water supplier in some of the specific provisions does not alter this requirement in the broader provision that A's wholesale water supplier provide a drought contingency plan. The port did not submit a drought contingency plan at all. That much is undisputed. Thus, this requires denial of the application. With regard to the water conservation plan, the ALJ's properly found the port's application is subject to the requirements of 288.5, but the ALJ erred in finding those requirements to have been met. In several instances, the port has provided responses which merely parrot the general requirement of the rules, but do not demonstrate compliance with the rules. For instance, with regard to the requirement of the regulation that a conservation plan include a monitoring and record program for determining water delivery cells and losses, Port has merely stated that an appropriate monitoring and record management program will be employed to track delivery cells and losses. Of course, given that the port has no intent itself to use the permit, this seems to be the best that it can do. But such general statements do not demonstrate that the particular requirements of the rule have been met, and they entirely deny the public the right to participate in whether those requirements are going to be met, because what is going to be done remains a mystery. The applicable water conservation plan requirements also require an applicant to establish that no feasible alternative exists. The regional water plan ranks 30 water supply strategies above this desalination proposal. Port's own witness did not contest that all of these are feasible. Where an applicant's own witness has acknowledged the existence of feasible alternatives, it cannot be said that the applicant has demonstrated no feasible alternatives exist. The port has also failed to comply with regulatory requirements regarding the identification of the surplus water return location. Rule 295.8 says the application shall describe the location at which return water or surplus water will be returned to the stream. The term surplus water is defined by regulation to be water taken from any source in excess of the initial or continued beneficial use of the appropriator for the purpose or purposes authorized by law. The brine reject water is precisely such water. It is water beyond that which has been appropriated for the purposes being authorized. Yet the only identification of the location of that surplus water return is into the bay. This is not a location. That type of broad generalization does not identify the location of return water. The ALJs do not find that that is appropriate. The ALJs find that that issue is outside the scope of this proceeding because it is wastewater that's being returned. The port's own witness was clear that water may be both wastewater and surplus water. They are not mutually exclusive, and there's no excuse to deny the applicability of this rule in your water rights regulations merely because it's an issue that will also need to be addressed in your wastewater regulations. Thank you. I yield the remainder of my time to Ms. Perales.
Thank you. Good morning.
Good morning. Marisa Perales for the protestants. The location of the proposed facility is in an estuary of national significance with seagrass beds nearby that provide critical reproductive, feeding, nursery grounds for a diverse range of species. And it's in an enclosed bay system. In short, it's an area that's ecologically valuable, but stressed and risky. And the facility that's proposed would be one of the largest desal facilities by volume in the country. And so it's particularly important to conduct the site-specific assessment that's contemplated by Chapter 11 to understand the impacts on aquatic resources of all trophic levels, including entrainment of organisms that form the base of the food web in the bay. And then it becomes important to craft permit conditions that are necessary to protect and maintain those resources and habitats. That's what's required by the law. That's the current state of the law, even where e-flow standards have been adopted. It wasn't done in this case. The assessment, let's talk about that first. The PFD and the applicant list a number of reports suggesting that because the applicant's witnesses reviewed these reports, a thorough assessment must have been done by the port, even if it wasn't done by the executive director's staff. But the listing of a number of reports and resources doesn't equate to the type of site-specific and resource-intensive assessment that's required here and by Chapter 11. And the reason we know that a true assessment wasn't performed is because Dr. Fontenot, the port's expert, essentially told us so. His opinion, summarized, is that the daily intake flow volume represents only a small fraction of the total volume of water in the entire bay. And so he concedes that ELS, or early life stage organisms, will be fatally impacted by the intake. Massive quantities of larvae and eggs that float by the intake structure on their way to the seagrass beds will be fatally impacted. But his opinion is that when you compare the populations of these ELS organisms to the entire bay system, it's not a problem. And the PFD essentially agrees. So to be clear, that's not an assessment. There was no assessment of how the complete removal of ELS organisms from the food web will impact the greater ecological health of this sensitive and stressed site that supports important seagrass beds. Certainly not the type of assessment that can inform the types of permit conditions necessary to protect aquatic resources and their habitats. And so here we have essentially no enforceable protective permit conditions. We have promises from the port that the design of the intake will provide protections, including limits on the velocity of the intake, but there's no monitoring requirement here to make sure that the intake velocity is functioning as the port has promised. And to be clear, it wasn't our burden to prove that monitoring devices are impractical that our monitoring devices are reasonable and practical. It was the port's burden to prove that such monitoring devices are infeasible, and they didn't do that. The impingement and entrainment measures, those were not based on a site-specific assessment, and they're not going to protect the massive quantities of larvae and eggs floating to the seagrass beds and past the intake structures. There was no real consideration given to finding another suitable location away from the seagrass beds, away from this estuary of national significance. There was no consideration given to restricting the times of operation or the seasons of operation to avoid when certain ELS organisms are likely to be in the area. In sum, Chapter 11 was not complied with, and so the permit should be denied.
Cool.
Thank you.
Thank you. Seeing no questions, thank you.
We have the ED.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Ruth Takita. I'm an attorney with the Environmental Law Division, and I represent the Executive Director, or ED. And with me at the table is Dr. Kathy Alexander from the Water Availability Division. The ED views this application as straightforward. It requests authorization under Texas Water Code Section 11.121 to divert state water, which the applicant plans to desalinate for industrial use. ED program staff reviewed the application, analyzed it under applicable requirements, concluded that it met those requirements, and prepared a draft permit. The ED position has not changed based upon the evidentiary record in the contested case hearing. The ED generally supports the PFD as set forth in her PFD exceptions and reply, but recommends that granting the application and issuing the permit as drafted by the ED. However, if the Commission determines that revision of Special Condition 5B is warranted, the ED respectfully recommends using language from a previously issued permit as discussed in the ED's exceptions. The ED believes this language is adequately protective, yet provides flexibility to allow for changes in technology between permit issuance and intake construction. We are available for questions, and we thank you.
Thank you. Seeing none.
OPIC.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. I'm Eli Martinez, Acting Director while Mr. Arthur's away from the office. We participated in these proceedings and conclude after reviewing the relevant evidence, briefing, and the administrative law judge's proposal for decision that the applicant has met its burden for issuance of the draft permit in this matter, and the permit should be granted. In particular, we agree that because the applicant is not a wholesale public water supplier, a DCP was not required for this application, that the water rights will not be impaired because the available supply consisting of seawater is continually replenished and the surplus water return issue is more appropriately addressed in a TIPD's proceeding, that currents at the intake structures will not pose a threat to persons or wildlife. To the extent that environmental assessments performed under sections 11147D and E and sections 11150 through 152 are applicable to this appropriation, that the applicant sufficiently evaluated potential impacts on water quality, fish, and wildlife habitats, that the permit is consistent with the State Water Plan and 2021 Region N Plan, and the permit would avoid waste and achieve conservation. Further, we support the ALJ's proposed amendment to Condition 5B requiring implementation of the design criteria proposed in the application to ensure reasonable mitigation strategies will be employed. And for these reasons, we agree with the ALJ's proposal for decision and support issuance of the permit. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. Seeing none.
Stephanie Bergeron, Purdue.
Just for
Thank you.
clarity, how much time do we have?
She has 4 minutes and 50 seconds remaining.
Thank you.
Thank you, Commissioners. I'm going to address 4 issues. First, with regard to the drought contingency plan issue. Simply stated, the Water Code 11.1272 requires wholesale public water suppliers to develop drought contingency plans. The port is not a wholesale public water supplier because it will not supply water for human consumption. Accordingly, the executive director did not require a drought contingency plan, nor is one required under law. With regard to the water conservation plan and all of the discussion on this topic, what stands out is the fundamental consideration, and it's why I believe the executive director required the port to submit a wholesale use water conservation plan in contrast to the industrial one they initially submitted. And that is because 288.5 requires successive wholesale customers to develop and implement its own water conservation plan, which supports avoidance of waste and achievement of water conservation by an ultimate end user. The port evaluated alternatives to new water development, which included but are not limited to 5 listed options. Desalination is an alternative to freshwater appropriation. The 2022 State Water Plan identifies an industrial shortage for this region as early as 2030, which is only 6 years away. The application was submitted in 2019, and we are now in the year of 2024. This evidence is the fact that long-term planning for a future project like this is required. There is not a requirement for an end user contract. This is not a speculative application. Turning next to the issue of waste and return water. The notion here, and this has been discussed extensively, is that there is brine involved with appropriating, diverting, and using the seawater. And then when the water has been beneficially used and not consumed, it will be returned to the bay. At that point, it cannot discharge into the bay without having a Chapter 26 permit to address the water quality impacts. That is in short, that is the long and short of this issue. Protestants have focused on a sentence in 297.48B, which describes waste as including a diversion that causes or threatens pollution, but the act of diverting the water is not the cause for pollution here. Return waters must meet the water quality standards. And in fact, the definition of waste says that the beneficial use of that water in essence subsequently requires treatment prior to discharge, but that is not waste for purposes of Chapter 11 of the Water Code. Returning to e-flows, one item that was mentioned was the enforceability and that there is no condition for monitoring the flow velocity. And I think that the records show that there wasn't evidence that such technology exists. The idea that there hasn't been a site-specific assessment here is unwarranted. There is extensive evidence in the record. And yes, Dr. Fontenot may have, I would say, focused on a great extent of the degree of site specificity for the Corpus Christi Bay. It wasn't just that there was the volume comparison of the bay to the intake to the diversion. That was one important consideration. There are other factors that were taken into account with respect to the intake structure. And that has to do with the height above the bottom of the bay, proximity to the shoreline. There were studies that looked at more of an on-take-in structure. That's not what this design is for. It is approximately 1,000 feet from seagrass beds. So there are a variety of factors that go into the evaluation of this intake structure, and the record does not support the statement that a site-specific assessment was not done. And I'll just stop there and let the record speak for itself.
Thank you. Colleagues, any questions? All right. Appreciate the presentations and appreciate the arguments. Colleagues, I think the bottom line for me is that I don't see a basis to change any of the ALJ's findings or conclusions. Commissioner Janek, other than there are a few clerical errors that we would correct. Commissioner Janeka?
I agree.
I'm in agreement.
Sounds like we're ready for a motion.
On the motion, and I move that we adopt the administrative law judge's proposed order with the following changes. Amend findings of fact numbers 37, 80, and 85 to include the clerical or typographical corrections recommended in the ALJ's reply to exceptions, and correct finding of fact number 97 to correctly identify the ALJ's recommended language for special condition 5B consistent with ordering provision number 1, and issue water use permit number 13630 to Port of Corpus Christi Authority of Nueces County in the form of the draft permit with the following change. Amend special condition 5B to read, quote, 5B, permittee shall implement reasonable measures to reduce impacts to aquatic resources due to entrainment or impingement. Such measures shall include, but shall not be limited to, following the design criteria proposed in the application for the diversion structures and the installation of 1/4 inch by 1/4 inch wire mesh screens at the diversion structures, end quote.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Of that, the significance of that, I apologize, is that the 3 MUDs are going to share the costs associated with the infrastructure for the water and wastewater on MUD number 1. And the ALJ's proposal to not approve it was based on the ALJ's view that the cost estimates were not high enough. Notwithstanding the fact that Mr. Heroy, Mr. Millsap, and Mr. Samuel, all engineers, said that they were reasonable estimates and that it was economically feasible. And the basis of that is because she did not take into account the cost sharing arrangements. And basically she said, well, I didn't see that in the record. Well, Mr. Millsap testified that if you looked at the itemized costs, that it shows the proportionate share is based on the number of homes. And the interesting thing about this is the application before the commission, Ellis Ranch MUD number 1, is actually the least dense of the 3 MUDs. It has the large pond and the dam and the grassy lands for absorption. So it is the one that when you do the proportionate share, and it's in the record based on Mr. Millsap's testimony, it only will pay 25 cents for every dollar in the infrastructure cost. And again, these costs were already approved by this commission in connection with the applications of MUD number 2 and MUD number 3. So basically, the statute requires just a tentative itemized cost estimate of the proposed construction costs. It's tentative, and even the expert for the opposition said that the protestant said that, well, that's just conceptual. Obviously, there can't be a whole lot of specificity, but the ALJ had tried to hold it to a higher standard, saying that, well, if you increase the cost by 50%, then the numbers don't work. Well, that would happen in any situation because when you do your proposal, you want all the numbers to match up. So you make assumptions and have contingencies built in. And if you increase the cost, again, MUD number 1 is only paying 25 cents for every dollar increase, and that was not considered. And that was not disputed. The itemized cost, it's important that Mr. Lozano, when he testified, he didn't even go through and challenge any of the itemized cost estimates. He just ballparked it. and said, I think you're off by about 50%, without any establishment of how he arrived at that number. And the ALJ took that and said, well, if I put in 50%, even 25%, the numbers don't work. But more importantly, she even took that number with respect to the roadway cost and said the roadway costs were off by 50%. When Mr. Lozano testified that he had done no review of the roadway cost because he could not find any estimates for the asphalt, and the asphalt's over 87% of the total roadway costs. So the ALJ, when you get to the irreducible nugget, she was trying to hold the tentative initial estimated cost to the standard of saying you need to come up with pretty specific costs of what it's going to cost now. And there was no dispute that the costs have increased since the application was filed. It's been pending for over 2 years. But the point is that the cap, the ALJ basically erroneously said that because the costs increase, if you're going to hit the $1 cap on your tax, then the increase would make $1.05, and then you would violate that rule. Well, the $1 cap is a cap. You're not going to go over. And if you go over that cap, it's the developer or some other source is going to fund that. And she did not take that into consideration. And the fact is that this is an applicant that there was no question has the financial backing to pay any overages that occur. And for that reason, we believe that the commission should not adopt the ALJ's proposal that this is not an economically feasible MUD, and instead approve the application as the staff has recommended, because the staff has reviewed this in connection with MUDs 1, 2, and 3, and even after the hearing still recommended that it be approved because, again, the tentative itemized cost is just basically a pro forma, and it should not be held to a higher standard of us trying to predict the future of what the actual costs are going to be. And for that reason, we believe that the application should be approved. And I can answer any questions.
Thank you, Mr. Ruiz. Questions? Seeing none.
Thank
Thank you, sir.
Thank you.
We have Ms. Emily Rogers for the protestants.
Morning, Ms. Rogers.
Good morning. Thank you all for having me today. Chairman, Commissioners, for the record, I'm Emily Rogers and I represent Ellis County. I want to address a few items in advance that were spoken today by the applicant. Some of the things that were suggested are in the record, maybe really aren't in the record in the way that they were proposed. I would also say that the cost estimates that were done by the county were done on 2022 cost estimates. The county agrees with the administrative law judge's recommendation to deny the creation of Ellis Ranch MUD number 1. MUDs are very advantageous to landowners and developers as they enhance the value of the land and the marketability of the land, and allows the developer to be reimbursed by the MUD for the costs associated with the infrastructure. The MUDs also have the power to condemn, levy taxes, enter property, employ law enforcement, in addition to providing water and wastewater service. Conversely, these developments within the MUD can have negative impacts on the surrounding land and natural resources. Thus, in order to balance those competing interests, the Texas legislature has adopted Water Code Section 54.021, which lays out what the commission must consider when granting or denying an application. The Water Code requires that this commission consider determining whether or not the project is feasible and practicable and necessary and would benefit the land. It must assess the reasonableness of the cost for construction, the tax rates, and the water and sewer rates. In doing all this, the commission must also determine if the district and subsequent development will have an unreasonable effect on things like natural runoff rates, drainage, water quality, groundwater levels, recharge, subsidence, etc. In considering the reasonableness of the projected cost, tax rates, and water and sewer rates, the purpose of this review is to ensure that the MUD will be a financially viable entity and that the tax rates are within the allowable limit. In this case, the applicant grossly underestimated the cost of the proposed facilities. While the county agrees that the preliminary engineering report, which provides the cost estimate, is just that, preliminary, it must be realistic. It must present realistic costs of construction so that the feasibility of the proposed district creation and subsequent development can be analyzed. Simply, the applicant failed to do a realistic cost estimate for this project. With respect to the other factors that are listed in 54.021, the Commission's review of these factors should be more than conclusory and cursory. The Commission should not abdicate its statutory requirements to other local government entities whose authorities and responsibilities are different than that of this agency. Section 54.21 directs this agency to review and analyze the effects of the creation of the district and subsequent development will have on these natural resources, not what a local government might consider what those effects might be. Here, the applicant failed to meet its burden to show that the district and subsequent development will not have an unreasonable effect on groundwater levels, recharge, drainage rates, runoff rates, and water quality. Conclusory statements about these impacts is insufficient. The county respectfully requests that the Commission adopt the PFD and deny the creation of this MUD, and I'll answer any questions.
Thank you, Ms. Rogers. Any questions, colleagues? Seeing
Thank
none,
you.
Thank you.
The ED next.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, Office of Public Interest Counsel. My name is Kayla Murray, and I'm an attorney in the Environmental Law Division representing the Executive Director. With me is Justin Tack, Manager of the District Section. The Executive Director respectfully recommends that the Commission issue the Ellis Ranch MUD number 1 order as drafted by the Executive Director and create the district. The petition is in compliance with all applicable statutory and regulatory requirements. The ED recommends that the Commissioners reject the proposals of the ALJs in their proposal for decision and create Ellis Ranch MUD number 1. Pursuant to Texas Water Code Section 54021A, the Commission shall consider the following factors when determining if a MUD should be created: the availability of comparable service, the reasonableness of projected construction costs, tax rates, and water and sewer rates, and lastly, whether the district will have an unreasonable effect on the following: land elevation, subsidence, groundwater levels, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land located within the district. The ALJs concluded that the applicant did not meet the following requirements: the reasonableness of projected construction costs and tax rates, and whether the district is economically feasible, whether the district will have an unreasonable effect on the groundwater level in the region or the recharge capability of a groundwater source, and whether the request for road powers meets the applicable requirements. Starting with the projected costs, as stated in the ED's closing argument, the applicant's projected costs are reasonable when compared to other taxing authorities in the area. It is also well established that the reasonableness of the projected costs and rates are determined at the time of the petition. The ED found these costs contained in the preliminary engineering report to be reasonable. Regarding the cost contingency, the ED cannot weigh in on what an appropriate contingency percent is for any district creation application. But it should be noted that there was nothing in the application materials that indicated that this contingency percentage was inappropriate, and that the Commission approved a 5% cost contingency for Ellis Ranch MUD numbers 2 and 3. Lastly, the projected tax rate of $1 per $100 assessed valuation is comparable to other districts in the area. The tax rates for each bond issue will be reviewed and justified on its own economic feasibility merits before issuance. We'd also like to point out that the economic feasibility rule that the ALJs point to is for the issuance of bonds. There are no district creation rules that speak to economic feasibility. Moving on to whether the district will have an unreasonable effect on groundwater, as the Commissioners have noted before, the legislature did not intend for the TCEQ to regulate groundwater through the creation of MUDs. We agree. Additionally, the district in this case will be receiving its water from a special utility district, not from wells or any other draws on this property. As such, no direct impacts on groundwater levels or recharge are expected. The applicant's preliminary engineering report, which was relied upon by the ED, also stated that the district would not significantly change the current drainage patterns or have any anticipated impacts on the recharge capabilities of the region. No refuting evidence was presented on this issue, nor was it shown that the level of impervious ground cover was atypical for this type of development. With respect to road powers, the ALJs agreed that the applicant met the requirements for preliminary layout, cost analysis, and detailed estimate, and analysis of financial and economic feasibility impact. These factors are all that is required of MUD applicants when requesting road powers. Since they were all satisfied, the issue of road powers is also satisfied. In conclusion, the ED would reiterate that this stage of the district creation process is preliminary. As is the case with virtually all district creations, estimates will change, costs will change, plans will change. It is the ED's determination that the applicant met its burden of proof on the factors set out in Texas Water Code Section 54021. It is also the ED's determination that this district will not create any more impact on the land than any other type of development. The ED recommends that the commission grant the creation of Ellis Ranch MUD number 1. Thank you, and we are available for questions.
Thank you, Ms. Murray. Seeing no questions, let's hear from the Office of Public Interest Counsel.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in this hearing, evaluated the evidence and arguments presented, and concluded that, in accordance with Texas Water Code Section 54.021B, the project is feasible, practicable, and necessary and would be a benefit to the land. Contradictory to the proposal for decision, we found that applicant carried its burden with respect to projected construction costs and tax rates, as well as groundwater levels. In agreement with the proposal for decision, we found that applicant met its burden as it relates to Texas Local Government Code Sections 42.042 and 42.0425, Texas Water Code Section 54.016, and 30 Texas Administrative Code Section 293.11A and D, as the applicant complied with statutory and rule requirements to initially submit a request for service when a proposed MUD is to be located within the ETJ of a city. Additionally, in our analysis as to whether the project is feasible, practicable, and necessary and would be a benefit to the land, we found that applicant met its burden as it relates to the availability of comparable service, the reasonableness of water and sewer rates, the reasonableness of effects on natural runoff rates and drainage, and the reasonableness of effects on water quality. For these reasons, we recommend that the Commission grant this petition for the creation of Ellis Ranch Municipal Utility District Number 1. Thank you, and I am available for any questions.
Thank you, Ms. Anderson. Seeing none. Mr. Ruiz, you have a mere 5 seconds for rebuttal. I don't know if you have a crystal you want to give us or pass on that. Okay, thank you, sir. All right, colleagues, I think I come down more or less where the Executive Director and Office of Public Interest come down. I disagree with the ALJs on a few pivotal points. First, I believe the record evidence does demonstrate that the petitioner's projected construction costs are reasonable. The petitioner complied with TCEQ rules to provide tentative itemized cost estimates. It worked with its contractor to confirm the pricing. The Executive Director's staff found the costs to be reasonable, comparing them to other district creation applications. The protestants offered a different opinion, which is fine. I will note that I found it conclusory, but that opinion did not, in my view, offer sufficient evidence to rebut the petitioner's demonstration that its tentative estimates were reasonable. The record similarly shows that the projected tax rates are reasonable, and I believe the ALJs conflate the analysis of the feasibility of road powers with the reasonableness of construction costs. And I don't see any evidence to rebut the petitioner's demonstration that the road powers are economically feasible. And finally, with respect to groundwater levels and recharge, the issue is whether there will be an unreasonable effect. Evidence that impervious cover is typical for the type of development could be a way of making that demonstration. But we certainly don't require the petitioner to show typical impervious cover. And here the petitioners demonstrated that there would not be an unreasonable effect in a different way. They did it with evidence that the developer will not be required to construct any infrastructure beyond what is normal for this type of development. And that is sufficient. And protestants' testimony that impervious cover may have an effect or can have an effect on groundwater levels and recharge is not enough to rebut that showing. So, colleagues, I would amend the proposed order and grant the petition. Commissioner Janeka, how do you see it?
I appreciate your explanation. I'm in agreement. Well said.
Commissioner Gonzalez.
I agree with you, Chairman.
All right, well, let me suggest this. I prepared a document that lays out explanation of changes in a little bit more detail that specifies the exact changes that I would make to the findings and conclusions and ordering provisions. And Ms. Smith, if you'll circulate that now to my colleagues and to the parties. I'm going to propose that we take a recess. We'll have you time to work through that and digest it, and then we can come back and discuss it on the other side. Sound good? All right. Why don't we, the time's 10:16. Why don't we take a break until 10:25? All right. We are in recess. All right, welcome back. The time is 10:26. We're back after a recess to consider the change document that I had circulated. And colleagues, did I allow enough time? We're good. All right. Commissioner Janecka, what are your thoughts?
I've reviewed the suggested changes amendment to the ALJ's proposal for decision, and I'm in agreement with those changes.
Thank you, Commissioner Gonzalez.
I'm also in agreement. I think this is well thought out and well laid out.
Thank you. Well, I'm going to go ahead and offer a motion then. Colleagues, I move that we adopt the ALJ's proposed order as revised by the change document that I have circulated today. I further move that we grant the applicant's petition for the creation of Ellis Ranch Municipal Utility District Number 1 and its request for road powers, and that we appoint the following individuals as temporary directors to serve until permanent directors are elected: William Reed Scoggins, Anthony Oliver, Tyler Anderson, Emily Subash, and Travis Chapman. That is the end of my motion.
And a second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by River Oaks Land Partners 2 LLC for amended TCEQ permit number WQ001 5559001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I agree with the executive director and the Office of Public Interest Counsel that Brian Keeley is an affected person. His property is approximately 0.6 of a mile from the facility, and he raises personal concerns relating to the potential impacts of runoff, including on water quality, as well as concerns about whether notice of this application was adequate. So I would grant his request and refer the notice issue and whether the draft permit is protective against runoff and protective of water quality. There were a couple of requests for reconsideration, which I think are, more or less subsumed into this contested case, and also did not really provide any new grounds for reconsideration. So I would deny those requests, and I would include with the SOA referral or an ADR referral.
I'm in agreement.
I also agree.
Okay, I think we're ready for a motion.
I move that we grant the hearing request of Brian Keeley, deny the request for reconsideration, refer the matter to SOA for a contested case hearing on the following issues: whether applicants substantially complied with applicable notice requirements and whether the draft permit includes provisions to adequately protect against runoff of treated effluent onto nearby property and is protective of surface water and groundwater quality. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the petition filed by Kathy Moore and Mark Albrecht for the creation of Williamson County Municipal Utility District number 48. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, again, I'm in agreement with the Executive Director and Office of Public Interest Counsel in this case that Williamson County is an affected person. The proposed district is located in the county, and the county has identified statutory authority over interests relevant to the application. These include county functions that would be affected by the petitioner's requested road powers. So I would grant the hearing request, and I would include an ADR referral.
I agree.
I agree.
I move that we grant the hearing request of Williamson County, refer the matter to SOA for a contested case hearing on the petition, and refer this matter to the Commission's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing scheduling process.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration for adoption of the draft 2024 Texas Integrated Report for compliance with Clean Water Act Sections 303D and 305B. The Executive Director's staff is here to present this item.
Okay, we'll start again. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jason Godo of the Water Quality Planning Division in the Office of Water. With me is Andrew Sullivan, also of the Water Quality Planning Division. The integrated report provides an overview of the state's surface water quality and determines if surface waters of the state are impaired or meet water quality standards. The report includes the Texas 303D list, which lists water bodies that do not meet the water quality standards. Development of management strategies to improve water quality may be needed for water bodies on the 303D list. For the draft 2024 integrated report, 1,103 water bodies were assessed. A total of 678 impairments are now included on the 303D list of impaired waters for 2024, compared to 650 impairments on the 2022 list. TCEQ staff worked with stakeholders to develop the integrated report that is being presented today. The Guidance Advisory Work Group met on October 26, 2022 to discuss the methodology that was used to develop the integrated report. The draft 2024 integrated report was released for public comment on February 9th of 2024, and the public comment period ended on March 12th, 2024. 3 public comment letters were received. Staff prepared responses to these comments, which are included in your backup material. Staff respectfully recommends approval and adoption of the draft 2024 integrated report and your direction to submit this report to EPA. We also request permission to make any additional non-substantive revisions if needed before submittal to EPA. Thank you for consideration, and we are available for questions.
Thank you. Seeing no questions. Thank you. Ms. Smith, has anybody signed in to speak?
We have an individual signed in, but they indicated that they don't wish to address the commission.
Thank you. And Mr. Martinez, what's the position of the Public Interest Counsel's office?
Good morning again, Chairman. OPIC recommends adoption of the draft 2024 Texas Integrated Report as presented by the Executive Director.
Thank you. Colleagues, I do too. Certainly appreciate the public comments, appreciate the support of the advisory work group, and I'm ready to adopt the report.
I move that we adopt the draft 2024 Texas Integrated Report for submittal to the United States Environmental Protection Agency as required by Clean Water Act Sections 303D and 305B as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration for adoption of the renewal with amendment to TPDS general permit number TXG 920000. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. And today with me, I believe available online, is Michael Parr with the Environmental Law Division. Staff requests adoption of a renewal with amendment of general permit number TXG 920000, which authorizes the discharge of manure, sludge, and wastewater into and adjacent to water in the state by concentrated animal feeding operations, also known as CAFOs. This renewal with amendment will replace the current permit, which expires on July 20th, 2024. The general permit was sent to EPA for review on August 18th of 2023, and the no objection letter was received on November 16th, 2023. A public notice was published in the Amarillo Globe News, Lubbock Avalanche Journal, and Houston Chronicle on January 26th, 2024, and in the Texas Register on February 9th. The TCQ conducted a public meeting on February 20th to take oral and written testimonies. The public comment period ended on March 11th, 2024. Public comments were received and a response to comments was developed and is included for you in the backup material today. Staff recommends adoption of this general permit and the response to comments. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We're here to answer any questions.
No one is signed in on this item.
Good morning again. OPIC recommends adoption of the renewal with amendments to the state-only TPDS general permit and the addition of pollution prevention requirements to address the use of anaerobic digesters as additional components of the waste management system in the production area of a CAFO for beneficial purposes associated with methane gas capture, which we believe does add clarity to our rules. We also note the extensive outreach to stakeholders and approval by the EPA of our draft permit, which additionally leads to the conclusion that the package was thoughtfully considered and in the public interest.
I fear my microphone's batteries may be going out. Let me try that again. Colleagues, I'm in agreement with Mr. Martinez's analysis, and I'm ready to go ahead and adopt.
I move that we adopt the renewal with amendments of Texas Pollutant Discharge Elimination System General Permit Number TXG 920000.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
Item number 7 is the consideration of gifts and donations of $500 or more in value given to the TCEQ submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. Seeing none, has anybody signed in to speak?
No one signed in.
Mr. Martinez?
OPIC supports approval and issuance of the resolution acknowledging the Executive Director's acceptance of gifts and donations in accordance with Chapter 575 of the Government Code.
Thank you, Mr. Martinez. Colleagues, certainly appreciate the donations. I'm ready to acknowledge acceptance.
I move that we approve the issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCQ Interoffice Memorandum to the Commissioners dated June 7, 2024, docket number 2024-0487-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which are items 8 through 47. And the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division. With me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 47. The total assessed administrative penalties are $975,527, with $101,390 deferred, $339,278 applied towards supplemental environmental projects, and $534,859 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. Any questions? Seeing none. Ms. Smith, has anybody signed in to speak?
So on items 10, 13, 14, 15, 16, 26, 33, 35, 40, and 44, we have people who are online are available for questions, but they haven't asked to address the commission.
Thank you. Mr. Martinez?
Good morning. We have reviewed these items, their proposed penalties, any comments submitted by the respondents, compliance histories, adherence to the penalty policy, notice and other procedural requirements, and at this time, we are satisfied these items comply with relevant statutes, rules, and policies of the Commission. OPIC is therefore prepared to support adoption of the proposed enforcement orders listed in items 8 through 47 of today's Commission agenda.
Thank you, Mr. Martinez. Colleagues, I'm ready to move forward with this docket.
I move that we adopt items 8 through 47 as recommended today by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Smith, please call the next item.
Item number 48 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Stedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through April. There were 419 effective administrative orders issued, and of those, 78 contained supplemental environmental projects. These orders assessed a total of $7,783,186 with a payable amount of $3,365,878. $3,723,374 are to be paid towards supplemental environmental projects. 10,417 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 1,278 enforcement action referrals have been received. There are 3,157 pending administrative orders with 1,640 cases that are on the backlog, which does indicate a small decrease again this month. 173 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,381 cases are being tracked for compliance. We are available to answer any questions you may have.
Thank you, Ms. Sedemeyer. Any questions? No, I think we're all paying attention to that backlog number, so we appreciate the trajectory anyway. Ms. Smith, has anybody signed in to speak?
No one signed in.
Mr. Martinez, what's the Office of Public Interest Counsel think?
No comments on the report, Chairman, though we do, as always, appreciate the efforts that it represents to ensure that the protections afforded by our rules and the permitting provisions that we apply to our permits and authorizations for public health and the environment have been appropriately adhered to.
Thank you, Mr. Martinez. And colleagues, no action is necessary on this report, so we appreciate the report. Thank you. Ms. Smith, when you're ready, please call the next item.
Item number 49 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 311, to implement House Bill 1688. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Rebecca Villalba with the Water Quality Division. With me today virtually attending is Michael Parr with the Environmental Law Division. This proposed rulemaking implements changes to the Texas Water Code made by House Bill 1688 from the 88th legislative session. This rulemaking would amend the watershed protection rules in Title 30 of the Texas Administrative Code, Chapter 311, Subchapter H, to expand permitting and financial assurance requirements for quarries to the new Coke-Stevenson Scenic Riverway, continue the requirements in the John Graves Scenic Riverway, and extend the expiration of the pilot program by 2 years until September 1st, 2027. In addition, the title of the subchapter H is being amended to be titled now Regulation of Quarries in Certain Water Quality Protection Areas. The proposed rule was published in the January 26, 2024 issue of the Texas Register. A public hearing was offered on February 26, 2024, and the public comment period closed on the same day. No public comments were received. Staff respectfully recommends adoption of this rulemaking to Chapter 311, Subchapter H. Additionally, staff requests permission to make non-substantive provisions necessary to comply with Texas Register requirements. Thank you. We're available for any questions.
Thank you. Colleagues, any questions? All right, seeing none, Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Wayne, what's the view from the Office of Public Interest Counsel?
Yes, excuse me. Yes, good morning, Chairman, Commissioners, General Counsel, and the Executive Director's staff. For the record, I'm Sheldon Wayne on behalf of OPIC. Our office has reviewed this rulemaking and finds that the amendments to Chapter 311 are necessary and properly implement recent legislation. The increased protection of water quality in the Coke-Stevenson Scenic Riverway provided by these rules directly benefits the people of this great state and is in the public interest. Therefore, OPIC supports adoption. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Colleagues, I think ED and OPIC did a very capable job of laying that out, so I'm not going to add to it. I'm ready to adopt.
I move that we approve the adoption of the proposed amendments to 30 Texas Administrative Code, Chapter 311, as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, please call the next items.
The next items are for closed session, and the commission will be meeting in closed session in room 247 of the Texas Workforce Commission at, would you like to say 11? Give people a chance to have a quick break.
Sure.
11, at approximately 11 a.m. as permitted by the Open Meetings Act, and we will be taking up matters, items number 50 through 53 as posted and noticed.
The time is 10:49 a.m. We are in recess.
The commission met in room 247 of the Texas Workforce Commission for closed session from 10:57 a.m. until 12:08 p.m. on item numbers 50 and 53 as posted in notice pursuant to the Texas Government Code. No action was taken. This agenda stands adjourned and the time is 12:10.